Hey, good morning, everybody, and welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you guys so much for being here. We got a big group of people already, and we passed a milestone just before we started this. 48,000 subscribers. You guys are fantastic. I can't believe how quickly we are growing. It's all because of you. So thank you all for being here so much and for sharing this with your friends and telling anybody and everybody about it. That was pretty exciting stuff. Tiffany was upset because she really likes when we hit a milestone while we are doing a live. But unfortunately, everybody was too eager to subscribe. So we hit that just before we went live. But thank you guys for being here. Introduce myself to people who are new. My name is Joshua Ritter. I am a former prosecutor with the LA District Attorney's Office. I was there for about 10 years. I left and went into private practice as a criminal defense attorney. This is Courtroom Confidential, where we do our best to give you both sides of the courtroom with my experience. And we hope that we do that. And this is Sunday Fun Day, where you have left us messages all throughout the week, and we are now going to answer them live and put you on the map and try to give you as many answers to your questions as I possibly can. I will tell you, you guys showed up this week because we got way more questions than I could possibly answer in the time that we've kind of given ourselves this morning. So I've tried my best to answer every topic. I wasn't able to get to everybody's answer. I hope that doesn't discourage you. Please continue to ask questions. I try to spread the love as much as I can. And I try to shout out people who asked similar questions, but you guys really, really showed up. So thank you so much. It really warmed my heart to see how many people want to participate and leave us a message. Please stay to the end. We always have announcements. Good morning to everybody who's already in the chat. JC Broadway and Becky B and Glinda and Flora Paris and Alicia K. Mayo and Hazel and Annalie Fitch, everybody who showed up. Hello to everybody who's watching on Facebook and X and everybody who's watching this on replay. We love having you all here. I get screamed at if I take too long. Thanking everybody in the beginning. They say, get to it, Ritter. Get to it. Alicia K. Mayo says, 48,000 and Sunday Fun Day. What a great day. I agree. Should we just jump into these things? A lot of great questions this morning. I want to cover as many of them as I possibly can. I think that's everything I wanted to tell you ahead of time. So let's just go ahead and do it. All right.
Hi, Josh. This is Polly from South Haven, Minnesota. My question is, how or when do you think Kohberger figured out that he didn't have his sheath? Did he do it while he was walking through the house when they show those video camera? At what point do you think he figured out he doesn't have his sheath? I know it's a really simple question, but I thought it'd be good to see if you had any idea when he would have discovered he didn't have it. That's all. I really appreciate your show and love watching you on YouTube. And you guys are great. Thanks.
You're great, Polly. I hope you're here this morning to hear the answer to your question. Calling from South Haven, Minnesota, kicking us off. Let's go ahead and put you on the map. I think that's the first time we've heard from South Haven, so thank you for calling. I love this question. You said it's a simple question, but it's a great question. It's also one of those questions that who knows if we'll ever get the answer to it, which is frustrating because I would love for the prosecution to sit down with him and grill him on all of this and give us answers to all of these questions. But for now, we're left with somebody like me just speculating, or all of us just speculating. And it is an interesting thing to think about because obviously he didn't intend to leave that sheath. I've heard that there were some theories that he left it on purpose to kind of taunt law enforcement. I don't think so at all. I think that was clearly a mistake. I don't think he ever, as meticulous as this guy was with the fact that throughout this entire murder scene, this is almost unheard of. Throughout this entire murder scene, the only genetic material, the only evidence left behind by the defendant was some trace DNA found on that snap, that button snap of the sheath that you see there. Nothing found in his vehicle, nothing found in his home. no hair follicles, no fingerprints, nothing left at the crime scene is remarkable. And to me, speaks to someone who took the planning of this, in particular, the cover up of this, very carefully. And so the idea that that person would then taunt the police with a piece of evidence that had his genetic material on it, I don't find to be true. I think he was surprised. I think he came into this home with the intent to kill one of the girls. It looks like it was Madison Mogen who was his target. I think he got surprised to find that there were more people there. I think he got surprised to find that Xana was still awake. I think that he left that sheath on accident. That's my view. And going with that theory, which I think is pretty sound, which most people would agree with, when did he realize he had left it? Well, I doubt he realized it in the chaos of the moment, in the frenzy of going from perhaps only planning one murder to now having killed 4 people. We've talked about before, there was evidence that he sat down at one point because he may have been exhausted. I mean, you just got to think about the chaos of that. And by the way, it all taking place within minutes. He was there for just a very short period of time, which is also shocking to think about, that amount of blood loss and murder taking place in a short period of time. And I think he realized, I need out of this house. And I think he got out of the house, started to drive. And I think somewhere along the lines, in that drive, he figured out, I don't have everything I came in with. And he may have had a checklist for himself. Oh, Anjanette's here. Hey, how are you? Well, maybe we'll see if Anjanette agrees with me on this theory. I think that somewhere on his drive, he stopped, kind of collected himself, maybe cleaned up, maybe removed some clothing, put it in a trash bag. He's doing a checklist and he realizes, dear God, I left behind the sheath. I believe that's why he went back. It also could have been that he went back just to see have police arrived. It has this chaos that I hope to put in place. Have people now responded to that? I think he might have been surprised to see that no police were at the home just yet. And I think he realized that morning. But we know for sure that he realized within days, because he's already searching Amazon for a replacement knife, because he likely disposed of it, and a replacement sheath, because he's also thinking, if I'm a suspect, what are police going to be looking for? If they realize I have bought a knife and sheath previously, they're going to say, where is that knife and sheath? And they're going to want to check it. And maybe I should have a clean one sitting around. And he hadn't exactly planned for that contingency. And he searches Amazon, and then he doesn't buy it. And then he erases his search history. And you can almost see the mental gymnastics he's going through. Should I do it? Shouldn't I do it? Is it better if I buy it now? Does it look worse? Does it look worse if I don't have it if they show up? Should I just say I lost it? Should I show them the replacement and then they realize it's a replacement from my search history? You can see him kind of spinning out in those moments. But I think that it probably was that morning. And at the very least, it was when he was making that search, which we know for certain that was not, well, we don't know for certain because we've never heard from him. But I think the most educated guess is that he thought in that moment, when he's doing that search, I've got problems. I've made a mistake. That's why I think it's a mistake. I don't think he planted it. That search afterwards is probably the best indicator it was a mistake. But great question, Polly. And thank you so much for kicking us off. Let's go ahead and keep it rolling here. What a great question.
Hi, Josh. This is Jenny. I'm from Inwood, West Virginia. And I have a civil question for you. So it's about the Karen Reed civil case against John O'Keefe's family. And I think I understand the res judicata term, where if she would have been found guilty in her criminal case, then they wouldn't have to relitigate her civil case. But does that not also work in the opposite way? Like, since she was found not guilty in the criminal case, does that not mean that the civil case should go away? I'm just curious. Anyways, I love your show. Thanks for all you do. Bye.
Jenny, thank you so much. I love this question as well. Great thing to think about now that the Karen Reed criminal saga is over. What's happening with this, the civil case? And just to clarify, I don't know if I misheard or you misspoke, but it's the O'Keefe family suing Karen Reed, along with a couple of the bars and restaurants that they were at. But they're suing Karen Reed civilly, wrongful death in regards to John O'Keefe's death. And you bring up an excellent point: is that what effect does the civil case have on a criminal case, or what effect does a criminal case, specifically a verdict, have on a civil case? Malibu Table Maven, good morning. Good to see you here. The idea is, first of all, they're independent. There's really no determination that comes from a criminal case that determines what happens in a civil case. But what will happen is, if you get a guilty verdict in a criminal case, you can use that abstract of judgment and enter it as an exhibit in the civil case. And so essentially you can tell the jurors in the civil case, look, here's 12 other people who had a much higher standard, a standard of beyond a reasonable doubt, found this person guilty for the same conduct that we are now suing them for. We would like to enter that as an exhibit. It doesn't tell them that they have to be found civilly liable, but it's certainly powerful evidence. So the way it works the other way is, if there's a not guilty, there's still a civil case that proceeds. Again, the criminal case doesn't determine the outcome of the civil case. And it's questionable as to whether or not that would even be entered in evidence in the civil case at all, because of this reason, because they are at dramatically different standards. A criminal case is at beyond a reasonable doubt. A civil case is at preponderance of the evidence. Well, we don't want the jurors in a civil case feeling that somehow an acquittal in a criminal case should mean something to them, because a person can be found not guilty criminally and found civilly liable, which does happen more often than you would think. Ever heard of O.J. Simpson? He was found acquitted for his murder and found completely civilly liable when it came to the civil case, because it was a preponderance case. So I think that will definitely take place here. What I should say is, the civil case will proceed here without impediment from the criminal outcome. And it's going to be interesting, because it's a whole different ballgame. It's a whole different standard. We're talking about, like I said, preponderance, which is basically, the way the law describes it, is more likely than not. If you want to say 51%, if you want to say 50% plus a feather, is the way I've heard it described before too. It just means, if you had to pick, more likely than not, which side are you leaning towards? And if you're leaning, that's enough. Whereas in reasonable doubt, it has to be beyond any kind of reasonable doubt, abiding conviction, all these terms that we use. It's a much higher standard. Oh, and by the way, I think I forgot to put you on the map. I'm being told by my producers, who are screaming at me in my ear, that I didn't put Inwood, West Virginia on the map. So sorry about that. There you are, Jenny. And thank you so much for asking an excellent question. So, what will happen in the civil case? Well, it's asking slightly different questions. It's asking about negligence. It's asking about, again, preponderance of the evidence, and it's different discovery rules. She can be deposed. She will likely be deposed, Karen Reed. Her Fifth Amendment rights no longer apply. She is not in any kind of jeopardy. She's been acquitted. So they can compel her to sit for a deposition. So that might happen. And don't be entirely shocked if there's a different outcome, because it's an entirely different standard. So that will be something interesting. Who knows when that's ever going to take place? These civil cases sometimes take years to actually head to trial, if they head to trial, and sometimes they settle. Oftentimes they settle. So we'll see how that whole thing ends up, and we will keep an eye on it. Let me do some thank yous. Esme, Grief, Thank you so much for gifting. Crazy Mom RN, thank you so much for the gift. Chihuahua Mama, thank you so much for the gift. Fancy Nancy, I love this. Thank you for becoming a member. Best Nancy, thank you for the gifts of memberships. You guys are fantastic. I appreciate it. Thank you for sending some love. And Anjanette, good to see you. Hope you're still here. And thank you so much for that very generous gift. We appreciate your support. All right, let's keep it rolling here.
Black Widow here in the Republic of Ireland. I was just wondering, do you guys know about the Irish true crime lullaby called the Weile Weile Weile? It's something that like it's a lullaby for kids. There was an old woman who lived in the woods, a Weile Weile Weile. There was an old woman who lived in the woods down by the riverside, yeah. She had a baby 3 months old, a Weile Weile Weile. She had a baby 3 months old down by the riverside, yeah. She had a penknife long and sharp, a Weile Weile Weile. She had a penknife long and sharp down by the riverside, yeah. She stabbed the baby in the heart, a Weile Weile Weile. She stabbed the baby in the heart down by the riverside, yeah. 3 big knocks came knocking on the door, a Weile Weile Weile. 3 big knocks came knocking on the door down by the riverside, yeah. Did you ever hear of it before? It's called the Weile 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 anyway. It goes on for another bit, but I think it's interesting and maybe you might want to look at it.
I love it. Black Widow, you made my day. That I love that. That's absolutely fantastic. If you couldn't tell, calling from Ireland, so let's put Ireland on the map. I have not heard this song. I will say it is shocking the amount of children's lullabies and songs have very dark histories to them. You ever looked into Ring Around the Rosie, where that comes from? Really interesting that we managed to I still sing some of these things to my kids, and then you do a little digging, you're like, my good grief, that's nightmare fuel. These are the lyrics to it. We looked it up. Weile Weile Weile. I'm not going to sing it. Here's the lyrics. It's a true crime mystery played out in a song. Maybe I will sing this to the little ones tonight. I don't know. The 2 policemen and a special branchman down by the river Sila put a rope around her neck. They pulled the rope. She got hung. And that was the end of the Woman of the Woods. So mystery solved. She took a penknife to her kid, and then she got hung. Thank you for that. Beautiful song, beautiful voice that you have, Black Widow. I appreciate you having getting the guts up to sing for us. That was a real treat, and I have not heard of that, and I feel better for now having learned about it. Philip Harrell says, if you get the opportunity, please ask Steve Gonzalez how it feels that his daughter is a hero. Keely fighting so hard may have been the reason the loser lost the sheath behind and was caught. That's an excellent point. And it's I've heard a few people mention that before. It should not be forgotten that it may not be, to our previous question, it may not be a mistake as much as it was a forced error because of the bravery of those girls, that the fighting him off caused him to drop it. Let's not give him so much credit for being forgetful. Let's maybe give some credit to the girls for fighting him off. So excellent point there, Philip. Appreciate you asking the question. All right. Who else has got a song for us? Let's keep it going here. What did I do? I lost my place. Here we go.
Hi, Josh. This is Rachel from West Palm Beach, Florida. I love your show. This is the first time I've called in, but this question has been on my mind for quite a while. Why didn't the feds place charges against Sean Combs for the weapons that they found and also all of the drugs, the illegal drugs? I'm just confused as to what caused them to leave those items out. If it was a warrant issue or something that you can tell us about legally. Thanks so much. Sorry, I'm a little under the weather. Have a great Sunday.
Rachel from West Palm Beach, Florida. Let's go ahead and put you on the map. Hope you're having wonderful weather down there. Here's first-time caller. Again, appreciate you calling in, and you got a great question. This, by the way, is a question that goes to, I think, the heart of the problem with this prosecution to begin with. They had obvious criminal charges. There were weapons charges available to them. There were drug charges available to them. But they didn't want those. They wanted a trophy. They wanted a RICO charge. They wanted something that would put this man in prison for life. They wanted to have that badge, to have that medal. Weapons charges, drugs charges, those aren't sexy. Sending this man away on some sort of illegal weapons charge, possession of narcotics charge, that wasn't the big whale they were looking for here. They wanted something with a splash. They remember this whole thing started with military-like raids of his homes in Los Angeles and Miami. And believe me, don't interpret any of my kind of frustration here as if I feel that this is an innocent man. I feel that this is a man who had for a long time been operating with incredible impunity and wrecking people's lives, and something needed to be done. And he had had evaded justice for far too long. But the feds come in with this big splashy production, and they raid his homes, and it's all over the news, and we're all waiting for these indictments, and they bring RICO, life exposure indictments. Oh my God. And then you find out they don't have the goods. They're trying to fit square pegs into round holes, and they don't have the goods. What they had were weapons charges and drug charges, and they tried to make those the predicate acts for the RICO, and it just didn't work. And what did they end up with? Well, they ended up with these, what we call Mann Act violations, transportation for prostitution. Again, not what they were looking for. They've got 10 years exposure on those. It's nothing to sneeze at, but it is not life in prison, which we were expecting. He's going to be sentenced soon. I imagine he'll be sentenced to something between the 3 and 5 years. He's already served time. He'll be out soon enough and having white parties. Watch. Just watch. He'll be partying in the Hamptons soon enough. And that's in large part because I feel they dropped the ball, because they overextended themselves and got out in front of their skis. And to your question, Rachel, that's part of the problem. It goes to the heart of the problem with this entire prosecution. Ali B from Tennessee says, when is his sentencing? Is he going to walk out on probation? That will make me very ill. I don't think you're going to be ill. I don't think he's going to walk. October 3rd, T-Suze, thank you so much, is when he will be sentenced. He's going to get some prison time. I don't think a judge could sit through that entire trial and hear everything he did and see that video of Cassie and let this man get probation. He's getting prison time. It's just not going to be what anybody was contemplating when they went into this. All right. Let's keep it moving here. IGG, I appreciate that comment. I do agree. I don't think this is the end of it. I think that this guy is so lost, and he's now probably figures he's entirely untouchable, that I think we probably will be hearing from him again. So thank you again, Rachel from West Palm Beach. Appreciate the call. All right, let's keep it rolling here.
Hey Josh, I just had a question about whether or not in this litigious society we live in, can the um, parents of the victims in Idaho sue the university at all? University of Idaho, because the students were living in campus-owned housing. Um, in fact, the campus knocked the house down. It was theirs to do with what they wanted. So I just wondered about that. Okay, thank you. Bye-bye.
Great question, Gloria. And before I get to the answer to your question, we had another question that was very similar. And this is where I'm trying to kind of double up so that everybody gets a little bit of attention here. But Gloria is calling from Florida. But let's play another question here. Are you hearing that or no? Oops.
Hey y'all, this is Holly in Houston, Texas with a question. I'm going to try to talk fast because I've got some video references to support my question for context. So I'm paused at just after 11 minutes of a 27-minute, 52-second video that Ashley Banfield put on her Drop Dead Serious YouTube channel with Steve Gonsalves. And at that timestamp, if you listen just a little bit ahead of that, they're talking about a civil suit for wrongful death. Steve made a comment that civil suits have to be filed within 2 years. So, and it's just been just over 2.5 years, will be 3 years as of this November. So is it possible, and I absolutely think it is, because I don't trust her as far as I can throw her, that Ann Taylor put all these delays, not just claiming she didn't have enough time, even though she took on another DP case, we'll leave that alone, as well as get the DP off the table, but to possibly prevent a civil suit from being filed because it would be outside the time frame. Chris McDonough did a great job lining out Taylor's tactics in his coverage of the gag order today. You can go to his channel, and I think it's just over 2 hours, maybe just under 3 hours long, and go to about the 48-minute timestamp. And he talks for about 10, 15 minutes, and he goes into detail, and I was really blown away. So interested for your thoughts. Thanks.
Great questions. So Gloria from Florida asked about, can the university be sued, essentially? And then we've got Holly from Houston. Good to hear from you again. Asking another question about the civil liability. Oh, look at that. The map just flies right over. We don't even have to get a new map. We just fly over to Houston. About the 2-year statute of limitations. And this all comes down to essentially what's going to happen now for Bryan Kohberger on the civil end of things. Can he get sued? Can the school get sued? Great questions. Here's the problem. I'm a criminal defense attorney. I was a prosecutor and now I'm a criminal defense attorney. The civil world, I've dabbled in it and realized it is not for me. I don't entirely know the answers to these questions, but ladies, Gloria and Holly, you can stump me, but you can't stop me. And that's because I can always phone a friend.
Joshua Ritter, my man. Statute of limitations on a civil lawsuit, Idaho, is 2 years. That means that day has come and gone for the families of the victims of Kohberger. The defendant, Kohberger, he's probably judgment proof, meaning he has no money to recover. So that is probably why there was never a lawsuit. I doubt that the dragging out of the criminal case was a strategic shield on civil liability. As to who else you might be able to sue, you can always sue anybody, but whether or not you could be successful is another question. I don't think in this situation you'd be successful against the university. It's my understanding at the time of the murders, the university did not own that property or those buildings. It was off-campus housing at that time. So if it had been on-campus housing, if it had been university-owned housing, that'd be another story. But in this situation, I don't think there was anybody to sue. And even if there were, it's too late.
That, ladies and gentlemen, is my friend David Gamble. We were in the same training class in the DA's office together. I've known him for, good grief, going on how many years now? Getting close to 20 years. That really just made me feel old. But yeah, I've known Gamble for a very long time. And he left the office soon after I left the office, and he went into private practice, but as a civil attorney. He is involved in personal injury cases, suing people, stuff like that. He's been on the channel before. Shy Girl says we like him. I like him too, and he's an excellent attorney. He's at gamel.law is his website if you want to check it out and say hi. We'll put up all his social media. He's got some YouTube stuff and everything like that. And he was kind enough to answer this question. And just to kind of flesh out what he said, yes, it is a 2-year statute, as it is in most places. So if they haven't filed before now, they are barred from filing. But the bigger question, and this is always the way to think about it with civil stuff that you don't think about it when it comes to criminal things, is you may be able to do something, but why would you? In other words, you may be able to sue Bryan Kohberger. Certainly there's civil liability there, but what are you going to get? Are you trying to get blood from a turnip? Does the man have 2 nickels to rub together? Does his family have any money? Does his family even have any negligence for just having birthed him? All of these are questions that a civil attorney is going to sit down and go. You don't want to just file lawsuits that cost money just to file lawsuits. So end of the day, sure, you could secure a judgment. You could get $1 million judgment, millions of dollars judgment against Bryan Kohberger. And you're never going to collect any of it. And that's what he meant by he's judgment proof. And the same thing goes for the university. You could sue them, but they could probably easily say, we have no liability here. We didn't own the home. It's a home that's near us. It's not associated with us. It was, my understanding was the home was contributed to the university afterwards because the owner of the home obviously felt like nobody's ever going to live this in again, contributed it to the university, and the university made the decision to destroy it. So again, you could sue them, but what are you going to get? Probably nothing, and they probably have no liability. So great questions, Gloria and Holly, but there's probably never going to be a civil lawsuit attendant to any of this. Now, they could do it. I mean, the Gonzalez family, if they just were like, we want to spend the money and we don't care, they could do it. They could do it. And sometimes people do that. They go on crusades and they're like, I know there's no pot of gold here, but I'm going to sue anyways. And they wouldn't be barred from doing that, but you've got a defendant who's got no pockets. What are you going after? And that's what civil stuff is all about. It's not about criminal. Criminal is about right and wrong. Civil is about, can you pay? Forrest Nelson, thank you so much for the gift of memberships. Appreciate you. Who else did I miss here, Tiff? Anybody else? All right. Thank you for that. Thank you for the questions. Let me see if I've completely thrown myself off here and I can move on to our next question. Yes, I think I have that capability. All right, let's keep it rolling here.
Hello, my name is Nina. I'm watching you from Sweden. I have a story about Bryan Kohberger and the hearing about the release of the gag order on the 17th. Do you know any more details about that? Thank you.
Nina from Sweden. I think that, let me see the map there, Kaylin. Is this the first time we've been to Sweden? I think it is. No, she's telling me no. We've got more than one person listening to us in Sweden. I love it. Well, hello, all of our Swedish fans. Appreciate you calling in. Appreciate you, Nina. And yeah, Nina asks about, yay, Sweden, says Simi Sharp. Nina asks about the Bryan Kohberger. That was the big news this week. We talked about it on the weekly roundup if you want to hear some kind of more details on this. But the latest thing to happen is the judge did lift the gag order. That was a hearing that took place on Thursday. A contingency of media outlets had gone to court and said, we want this thing lifted and we want it done now. And originally the prosecution had opposed it. Then they withdrew their objection. And then the defense said, well, we oppose it. And the judge at the end of the day said, no, the reason we had this gag order in place, there he is, Judge Hippler. The reason we have this gag order in place is he looks like he's casting a spell. The reason we have this gag order in place is that we don't want to affect a potential jury pool. We don't want people getting too much information, and therefore they walk into here with preconceptions and biases. That doesn't exist anymore. He's pled. He's now going to be sentenced. We don't have the same same concerns. So I'm going to lift it, and I think that was the right thing to do. Probably could have been kind of tailored back before now, but whatever. He went ahead and lifted it. So what that means, though, is the bigger question. What does that mean? That doesn't mean that all of a sudden we're going to get access to all of the police interviews and all of the police evidence and everything that we've ever wanted to see. What it does mean is that all of the victims' families, all the witnesses, law enforcement, prosecution, defense attorneys, any attorney involved, they can now speak freely. But it's up to them. So it doesn't mean that anybody's compelled to speak. In fact, the defense attorneys have already said they intend to never give a statement. The prosecution says they don't intend to really speak about it, certainly until after sentencing. The families can be much more vocal about it. The Gonzalez family has already done some interviews. The witnesses, we can hear from them now. They can start to tell us about things that they saw and heard. So that might be very interesting. And then there was the issue of the sealed documents. Many of these courtroom motions were filed under seal because of privacy interests and protecting the sanctity of the trial and the security of the evidence. And he's going to address that. But he even said in court, Judge Hippler, it's going to take some time. He's not going to do it before the sentencing. He's going to take some time. It could be weeks, it could be months, and he may not unseal everything, and he may unseal some things and then redact it. And so that's to protect overriding privacy interests. For instance, one thing I point to as a clear example of this is, you remember the defense filed that motion to argue an alternate perpetrator, and they identified 4 individuals. We will probably never learn the identity of those individuals through the court documents. That information will likely remain sealed, but those people potentially could go about saying, yeah, I was one of the people that the defense identified, or other people could talk about that, but the court is not going to unseal that. So Nina, if you're still up, if you're here and you're hanging out, thank you so much for the question, and thank you so much for calling from Sweden. Joe Schmo, hello, my friend, says, oh, so then what is the difference between a non-dissemination order and a gag order? The difference is it's 2 ways of saying the exact same thing. The non-dissemination order is the gag order. In court, they call it a non-dissemination order, but it's the same thing. It just means don't talk. Gag, don't talk. We're not going to allow you to talk about this, and it can apply to whoever, and it can be as strict as the judge wants. And I will say this too. Most cases kind of have the understanding that you're not supposed to talk about things. It's only in rare circumstances that judges will actually put a written order out there. Oh yeah. And by the way, we will be doing the sentencing. Thank you, Afton. Appreciate that. Let's give Afton a raise. I appreciate you, Afton, for remembering that. On CC Live Trials, our sister channel, we're going to be covering the sentencing. So that will be on Wednesday, and it might carry over into Thursday. And we will be carrying it live. So please check it out on Courtroom Confidential Live Trials, CC Live Trials. If you haven't subscribed there, please subscribe, set your notifications so you guys don't miss anything. All right, let's keep it moving along here.
Hey, Josh. My name is Jennifer Nielsen from Salt Lake City, Utah. I love your channel. I am calling with a question regarding the Bryan Kohberger case. I have followed this case very closely and watched numerous different outlets along the way, although yours is my favorite. I was particularly struck by your conversation with Brian Entin. I thought it was very enlightening. And I specifically was struck by what he said about the prosecution and the state of Idaho in general, how he just felt like the state wanted to get rid of the case and that they were annoyed with the case, etc. And then my heart goes out to Steve Gonzalez. It goes out to all of the families. I have children very similar in age to these victims, and I can't even comprehend what they've gone through. My question is, if you are the victim of a crime, do you have any recourse if you do not feel like the prosecution is doing what they should be? If you don't feel like their heart is in it, is there a way that you can request another prosecutor? And if so, what steps would need to be made in order to make that happen? I really appreciate your time. And again, thank you for all that you do. I learn something every single week. Take care.
Oh, Jennifer, you are so kind. Wow, what nice things to say. I appreciate it. Jennifer calling from Salt Lake City, Utah. Let's put that on the map. Great question. So yes, we did an episode with Bryan Entin. Bryan Entin is a investigative reporter and journalist with News Nation. He sometimes fills in as an anchor, and he's a phenomenal resource and a really good reporter. And he's the person who was the first to break the news that Bryan Kohberger was taking a plea in this case. I remember the day clearly. We were preparing to talk about the Bryan Kohberger case that night with Kevin Fixler. We were preparing to travel. I was preparing to go live in Boise for about 3 weeks to cover the case. And Tiffany yelps from the other room, "Oh my God." And I say, "What?" And she says, "Bryan Kohberger is taking a plea deal." And I said, "That's not true. Where are you reading that?" She said, "Twitter." I said, "Well, Twitter's full of Twitter. Twitter, yeah, X is full of nonsense. Who said it?" And she said, "Bryan Entin." And I said, "Oh my God, it must be true," because he's a very, very good resource. And we did an episode with him. You guys should check it out. And he was forthcoming about some strong feelings he has about this. We'll put the link up for you guys if you want to check it out. But he did not hold back about the prosecution in this case. And the judge, I think, a little bit too. He said that he just got the feeling none of them were really hungry to prosecute this case, and that they kind of were looking for an opportunity to get rid of it anyways. I hope that's not true. It's hard to argue. They did settle the case. It was shocking to people. I do kind of understand why they settled it. But a lot of people are feeling the same way. Like, why did we go through the last 2.5 years of all of this for it to end up this way? And Jennifer, to your very excellent question, what recourse does the victim's family have if they feel like the prosecutor is really not advocating for them? Here's some quick thoughts and something to keep in mind. First of all, the answer is they can't do much because the prosecutor doesn't work for them. In fact, the prosecution doesn't even represent them, really. The prosecution represents the people of the state of Idaho. When they make their appearance in court, the defense says, "I'm Joshua Ritter on behalf of Mr. Smith." And the prosecution says, "I'm Joshua Ritter for the people." They represent the population. They represent the prosecution. And so that's whose interest they have, is to see that justice is done for their community and not necessarily to represent the interests of the victims. Now, absolutely they care. Absolutely they should take those into consideration. Absolutely they should want the victims to have a voice and to be heard. But sometimes those two things don't entirely line up. Sometimes what the prosecution may feel is the interest of justice is not entirely in line with what the victim's family may feel. I've dealt with this. I've had cases. It happens more often than you think, where you have a case where, especially in murder cases, a loved one is lost and you make an offer to the defense that is less than the maximum. They feel betrayed and they feel like you don't care and that you've abandoned them because they've lost their loved one and they want the absolute maximum. And it's hard to explain to them why it might be a good plea deal and why there are other things to take in consideration and why sometimes the case may not be as strong. And this isn't just about taking chances. This is about making sure that justice is done. So it's difficult. That all being said, Jennifer, if there's really a problem with a prosecutor, they can of course work themselves up the chain of command. They can talk to people. And I'm sure that the elected DA there in Boise was well aware of this and had communications with the family. And if they wanted to say, this guy's just not it, he's not the right one, I'm sure they could have voiced those opinions, but they're not the ones really calling the shots. So I feel like it is sad that at the end of all of this, there is this kind of distrust and bad feelings between the prosecution and the families. And I hope that there's some healing there, because on top of all of that, the families certainly don't need this. And my heart does go out to the Gonzalez family that they don't feel that the right thing was done. Anyhow, great question, Jennifer. I'm sure a case we will be talking about for a long time to come, because it is such a significant case. Sarcasm. Hello, my friend. Says, hello, Josh and our badass CC fam. What are your thoughts on Stinky Sterns possibly taking a plea deal in one, possibly both cases? I have heard that it is all but certain that he's taking a plea deal on the SA cases, which were supposed to start on Monday. Or at least he is coming back on Monday to discuss possibly entering a plea. That doesn't shock me at all, by the way. That case was going to be about 5 days of jurors sitting just through brutal videotape and photographic evidence. There's no defense there. It's caught on videotape. They're just going to see awful, horrific images day after day. And thank God there's a possibility of sparing those people to have to look at that. And he would have gone down, and it just would have been, a slow plea, as we call it. So I'm not shocked by that at all. And perhaps too, he will, see the walls closing in and take a plea deal on the murder case as well, perhaps to avoid the same types of consequences for Bryan Kohberger. I mean, this beautiful girl here, Maddie Soto, led a tortured life. Can't imagine what this child had to go through in her short life to have been tortured and abused and molested, and then end up losing her life. What an evil walks amongst us sometimes. And so I'm not surprised about the one case settling, and I wouldn't be entirely shocked about the other one. But I just hope that the right thing is done by prosecutors. Vesper Martini says plea deal for both cases. That's news to me. I'd heard about the one, and maybe it is for both. So we will see. We will certainly give you guys the coverage on that if it does happen. All right, let's keep it moving along here. Let's keep it rolling, as they say.
Hey Josh, it's Farm Girl. Hey, I had a question regarding consent. So a lot's been brought up with that, like with cops searching the phone and whatever. So my question is, if a cop comes to me and they say, I want to see the text between you and your mom, can I go into my phone and pull up the screen that shows the list of texts between my mom and I and say, here, you can look at that? And then they can't look at anything else because that's all I've given them consent to look for, right? Or am I wrong?
Farm Girl, always planning things out. Farm Girl, always making sure she understands the play, and I appreciate that. Farm Girl calling from Ohio, from a farm somewhere in Ohio. Thank you so much. Appreciate it. Great question. Consent. First of all, the answer from your criminal defense attorney, and this show is not for legal advice, disclaimer. But the answer from your friendly defense attorney is don't consent to anything. Wait for a warrant, okay? Because a warrant can be challenged. Consent usually cannot. But if you decide that you're going to want to be friendly and helpful, you can limit consent however you want. If police say, hey, we would love to see a text message between you and your mom, you can say, sure, let me pull that up for you. Okay, I found it. And that is exactly what I'm showing you. And they say, well, can I see your phone? No, you can't. You see with your eyes, not with your hands. Here you go. And they say, well, can I see? I want to be able to scroll. No, this is what I'm showing you. And I'm not showing you anything else. Police are clever. And listen, I'm a big fan of police, but I'm also wise to their strategies, tactics. They're not, police rarely come at people heavy-handed. It's usually like, hey, help us get to the bottom of this. We're just trying to figure this out. Do you want to be, can you just be helpful? We would love to take a look at your phone. We're trying to just, answer some questions, close this whole thing out. Can we take a look at your phone? And you, being one, nervous because you're speaking to police, and two, a nice person, say, sure. And you hand over your phone, and they interpret that as consent to search your phone. And they start going through everything, your financial records and your photographs and your emails and your text messages and your geolocation and anything else they can find on that phone as quickly as they can, because they're going to interpret that as, sure, go ahead, consent to look at your phone. But you can limit that consent. You can do that. You can say, I am not going to hand you my phone. I'm going to let you look at it. If you've got a problem with that, sorry, I'm not comfortable just handing over my phone, but I'm happy to show you some text messages, and that's that. And if they want to go out and get a warrant, they can go out and get a warrant. But that's the answer to your question. Consent can always be limited. Consent can be denied. You could say, no, thanks, but no thanks. I mean, this is a typical situation. You get pulled over by police, and they say, do you mind if we take a look around? And you thinking to yourself, I am a law-abiding citizen. I've got nothing to hide. Sure, go ahead. Why not say why, or no, or I'm not comfortable with that, or no thanks? It's just, they kind of play upon these social norms. One last thing on this scope, the scope of consent will always be judged by a reasonable person standard. So you say something like, sure, go ahead. That's going to be reasonably interpreted as they can look through everything. You hand them and say, here are the text messages you asked for. That's what you can look at. It's going to be reasonably interpreted as that you have limited that scope. Great question, Farm Girl. Darlene 63, thank you so much, says, please consider reviewing the Melly case when and if it comes to trial. His defense attorney is facing charges too. I will have to check that out. I am not aware of that. Are we aware of that? I feel like we are. I'm being told, yes, we are. We will definitely look into that. Thank you for that suggestion. Thanks for sharing your knowledge. Also, Best Mod says, Fran, you're absolutely right. Fran's apparently a crab with little pinchers there. So thank you, Fran. And we do have the best mods. Appreciate you. All right. Let's keep it rolling here.
Hi, Joshua. This is Sarah from Bosnia and Herzegovina in Europe. I hope you're having an amazing Sunday and that you and everyone around you are doing great. I really enjoy listening to you all the time. Anyway, my question is about the Kohberger case. I'm wondering, after the sentencing, will the details that were previously unavailable due to the gag order become accessible to the public, or will they remain sealed now that the case is closed? So that's all for now. Thank you. Bye.
Sarah, this has got to be a first time. Sarah calling from Bosnia and Herzegovina. Thank you so much. I love that. I love that. What an international community we have. Can we zoom out for a second? There's oh yeah. We need to, there's still some territory we haven't conquered here, but thank you so much, Sarah. Appreciate you. Hope you're listening. Thank you for asking the question. Please call again. Tell all your friends. And you ask an excellent question about Bryan Kohberger. We talked a little bit about this before. This is what I will expect soon. Once that gag order was lifted, every reporter who's been following this case, Kevin Fixler, Brian Entin included, have been reaching out to every single one of these witnesses, family members, law enforcement, whoever they've had contact with before. They've likely spoken to all of these people. Maybe some of them gave some information on background. Maybe some of them said, I'd love to chat, but I can't because of the gag order. Maybe they've had some off the record conversations with some of these folks, but they've made the connections. And now they're just calling. When can we sit down? When can I interview? And that's what we're going to get immediately, is these interviews from people who are willing to talk. Witnesses, family members, perhaps some law enforcement. I think not as likely. Perhaps some defense team people. I think not as likely. But those interviews are going to start happening. That will be the immediate thing. But as far as crime scene photos, video of badge cam videos, audio tape of interviews, surveillance videos, all of that kind of stuff, the stuff that we really want to see, police reports, not going to happen. Not going to happen anytime soon for sure. Some of it may come out through the unsealing of court documents if those pieces of evidence were attached as exhibits. But there's all these gag orders and sealing orders don't apply to law enforcement who has the custody and control of the evidence. And that's going to have to go along the same lines. Public records requests from media, FOIA requests from media. Maybe some of that stuff will start to trickle out. Maybe some of it won't. I mean, many times they keep this stuff under lock and key because there is not the same compelling interests and First Amendment interests in the evidence as there is things done open in court. So great question, Sarah. Appreciate you. Hope that you're listening. And thank you for asking that. Leslie B says, oh, Leslie, thank you so much. I learned so much here. Thank you for sharing your knowledge. Oh, I'm happy to. Well, I'm very happy that you're here and feel that it's helpful. And then Von Smooth 01, thank you for becoming a member. Appreciate that. Having a great morning. This is a great morning. I'm juiced. You all juiced? You having a good time? We're talking about Bryan Kohberger. We're talking about a lot of Bryan Kohberger. Sean Combs a little bit. We heard an Irish lullaby that's going to give us all nightmares. We're having a good time. All right. Let's keep it rolling.
Hello, this is Carolyn from Highlands Ranch, Colorado. And I've got a question for you. I've been watching live stream jury trials lately on our live stream here in Colorado. And I've noticed that victims don't seem to be in the courtroom. And I'm wondering if I just can't see them or if they're not allowed to be present because they'll. Anyway, if you could just answer that, it seems like they should be able to be there, but I do understand if they have to be outside because of prior testimonies. But just wondering about that, and look forward to meeting you at CrimeCon here in Denver in a few months. Thanks.
Thank you so much, Carolyn from Highlands Ranch, Colorado. Let's put Highlands Ranch on the map. And of course, Highlands Ranch is near Denver, right? It's a suburb of Denver, it looks like. Yes. And because of that, we will be seeing you soon, Carolyn, at CrimeCon coming up here in September. So thank you for reminding us all about that. Here we go. CrimeCon, September 5th through 7th this year. We're going to be there. Carolyn's going to be there. Anybody else who's near there, be there, fly in. It's going to be a good time. And to give you guys a little bit of an incentive, and I'll talk about this again later, but we do have a discount code that CrimeCon gave to us for all of our Courtroom Confidential crew. And that is if you enter the code Courtroom, all one word and all in caps, when you check out to buy a ticket, you'll get 10% off. So that's nothing. That's not nothing. And we hope that that's helpful, and we would love to see you all there. I think it's going to be it's going to be the biggest one yet. And we're going to have a booth, and we're going to say hi, and we're going to be handing out stuff, and it's going to be fun. We're looking forward to it. But Carolyn, to your question about are victims allowed to be in court? And the answer is yes. Yes, they are if they're not testifying. And then sometimes they are even if they're testifying. If they're not going to testify about something that could be influenced by other testimony. In other words, if they're not percipient is what we call it. So just a family member testifying as to, the last time they saw their loved one who's now passed may not be as important as a eyewitness who saw the crime. If you're a family member and you're an eyewitness that saw the crime, you're likely going to be subject to a motion to exclude is what we call it. They call it different things in different jurisdictions, but that's it's because we don't want that person's testimony being influenced or even appear to be influenced by other testimony. Usually then after they testify, they can sit in court. But I have seen that in most cases, judges will give a lot of deference to the victim's family to allow them to attend as much as possible, even if they are testifying. But great question. Carolyn from Highlands Ranch, thank you so much. And we will see you at CrimeCon. All right.
Hello, Josh and the CC crew. Happy Sunday Fun Day. This is Miss Dina, also known as Dina, from Seeking Justice. Although as justice seekers can be found across the globe, I personally am calling from Seal Beach, California. My question today centers around the Stephan Sterns case, specifically regarding Jennifer Soto's derivative use immunity for her testimony in the investigation. Could you please explain derivative use immunity and if you believe she could still face charges if independent evidence has been uncovered? I also wonder what your thoughts are as to whether or not she will testify against Sterns in either the CSA case and or the murder case. Thank you for taking my question. Really enjoy your channel. Always happy to support you, and also want to shout out a special thanks to your mods. Hoping for swift justice for Madeline Soto. Have a beautiful day.
Thank you so much, Dina, from Seal Beach, California. Let's put you on the map there. Seal Beach is a gorgeous part of the California coastline. So thank you so much for calling in. Your question is an excellent one that it sounds like we may be having a plea and we'll never get the answer to your question as to whether or not Jennifer Soto will be compelled to testify. But you still bring up an excellent point about, and this is something that we hear from people a lot. We toss around this term immunity, use immunity, transactional immunity, derivative use immunity. What do these all mean? What effect do they all have? And I think that's something important to discuss so we all understand. First of all, use immunity or derivative use immunity is much more common. When we're usually talking about somebody received immunity, this is what we're talking about. Transactional immunity, which I'll get into, is incredibly rare. And you'll understand why as I start to explain the difference between the two. But use immunity prevents the prosecution from using the witness's testimony directly. In other words, what they say on the stand or during interviews, using those words against them to prosecution and any information derived from that information. So there's where you get the derivative use immunity in a subsequent criminal case against that person. So in other words, if she were given use immunity, they're saying to her, we're not going to use anything you tell us, and we're not going to use anything that we learn directly from what you tell us to try to build a case against you. Okay. But we can build a case against you if we have independent evidence. In other words, if we know that you were involved in a crime and it has nothing to do with what you told us or what we learned from what you told us, we can still prosecute you. So you're not completely off the hook. You're also not off the hook for unrelated crimes. It doesn't give you immunity for, narcotics crimes when we're talking about a child murder. But it gives that person, the reason that it's done is it's to give that person some, I don't know if you want to use the word comfort or something that they can feel, yeah, I guess comfort better about testifying so that they can testify and feel that they can talk about these things and it not going to be subjecting them to criminal liability and possible prison time. It also takes away arguments regarding Fifth Amendment issues. If they say, I can't testify to this, I've got a Fifth Amendment right. Prosecution says, we're giving you immunity. We're taking away your Fifth Amendment concerns, and judge can now compel you to testify. So that's the other reason for it. Transactional immunity, much more rare because it's much more inclusive. It prevents the prosecution for any crime related to the testimony, regardless of the source. So in other words, you're going to testify regarding your daughter's murder. If we give you transactional immunity, which I don't believe she's been offered here at all, would be shocking to me, means we will never, under any circumstances, prosecute you for that crime. Like I said, there's really I can't think of a good example of where you see that. It's usually only in situations where the prosecution needs this person so badly, and what they did is not so directly involved. In other words, she's not a good example, Jennifer Soto, but think about a situation where a person did something very low on the totem pole as far as their interaction in the criminal case, but they're very important. They might be given some sort of transactional immunity so that they don't feel like they're ever at risk with this important information. But again, I'm trying to think of a good example and I can't think of one. I've never been involved in a case in granting transactional immunity. In fact, I've never even heard of a case being granted transactional immunity while I was working at the DA's office. It's usually use immunity, and even then, extremely rare. When we would try to give immunity to people, we would have to work it up the chain of command, write memos, do a bunch of work, usually ended up exhausting the prosecutor before they even got to the point of using that person. And Mimi says, I just learned 2 new legal terms. Well, there you go, Mimi D. Worth the price of admission already. All right, let's keep it rolling here. Great questions, everybody.
Hi, Josh. My name's Hayley and I'm from Cornwall in England. I've got a couple of questions regarding the death penalty. Sort of sprung to mind recently with the Kohberger plea. If a person is put to death row, why does it cost so much? And my other question is, why does it take so long to get to the execution? I think there's a case at the moment, I think it's in Idaho, someone called Ralph Menendez. He committed a crime in the 80s and now he's due for execution. But he's got dementia, so now that's a query in whether or not the death penalty will go through. So yeah, that was kind of my thought, because even if someone's on death row, it doesn't mean to say that they're going to get the death penalty, and it may not be in the lifetime of the victim's family. Yeah, thank you.
Haley from Cornwall, England. Let's put you on the map. Oh, zoom in there. I did not know that. If you asked me to pick out where it was, I would have not said there. So thank you. Thank you for the geography lesson that everybody's given us this morning as well. The audio was a little rough, so I'll just kind of recap Haley's question, but it's a really great question that you hear a lot, especially when we're considering cases like Bryan Kohberger and the death penalty, and why did they take it off, and was it worth it? And she asked, well, how long can a person be on death row, and how much does it cost? And the cost really is hard to pin down, but it can be you hear these estimates about how many tens of thousands of dollars it costs to house an inmate every single year. It can be shocking amounts of money depending on how long that person remains in prison. So yeah, there's different debates and arguments people have about like, well, is it going to be more expensive to keep them on death row than it is to keep them life without parole? I really don't get into those arguments too much, because to me, it shouldn't be a question of taxpayer money. It should be a question of doing the right thing. But then the question becomes, okay, well, if we're doing the right thing, will the right thing ever get done? If that's the death penalty, are these things actually happening? Or is this all just kind of a theoretical exercise that we're taking, and that the person gets sentenced to the death penalty and that actually never happens? And she brings up the case of Ralph Menzies. This was a case I was not familiar with. I had to look it up. He was convicted in, or actually he was involved in the murder. He committed the murder of Maureen Hunsaker in 1986 in Utah. There she is. She was a gas station attendant. He was out on parole, I believe, for another crime. Not clear why he did this, but he ended up kidnapping her. There was some evidence that he may have wanted money. He had her call her boyfriend at the time. Really awful story. Horrific nightmare scenario for her. Kidnaps her, and then she is found later with her hands bound, tied to a tree with her throat slit. Just about a heinous crime as you can think of. And because of that, he was sentenced to the death penalty in 1988 in Utah. Here's what's happened since then. Here are all the years, all the dates that he has had either appeals or stays. So bear in mind, sentenced to the death penalty in 1988. He had an appeal denied in 92, in 1994, back again in 1995, in 2003, again in 2004, again in 2012, 2014, 2019, 2022, 2023, and again in 2023. He appealed on issues regarding reporting errors, ineffective assistance of counsel, ineffective DNA testing. He had a habeas hearing. He had a mental competency hearing. He had a clemency request. He appealed all the way up to the Utah Supreme Court. And he, in fact, appealed all the way to the Supreme Court of the United States. When we talk about Bryan Kohberger waiving appeal and how the family won't have to go through years and decades of appeals, this is what I'm talking about. It is endless. It is every issue. It is revisiting every issue. It's when you're talking about an appeal too, you're not just talking about one shot. Hey, I'm appealing this issue and I've been denied. Because what you do is you work your way up. Well, I'm appealing this to the appellate court here in Utah. I got denied. Great. Now I'm going to the Supreme Court in Utah. I got denied. Great. I'll appeal that same issue on the federal side of things and go to the circuit court. Oh, okay. I got denied. Now I'd like to go to the district court. Oh, okay. I got denied. Actually, I think I said that reverse. Oh, now I'd like to go to the Supreme Court. Appeal after appeal on the same issue, denied and denied and denied, years in between. Why does it take so long to write these things and bring them to court? Because of this incredible bottlenecking that takes place on the appellate side of things. There are only so many attorneys who can handle these things, and there are only so many courts that can handle hearing these things, and the courts don't sit every single day. They only sit in session for a few weeks out of the year. So it takes years for these things to be heard, and then they have all these opportunities to appeal. Now, if you're interpreting from what I'm saying as if I feel that that means the system is broken, to one extent, I understand it and I get the frustration, but to the other extent, I get the idea that people have rights and they have the right to appeal things and they have the right to be heard. And that many times some of these appeals uncover injustices that have taken place. This is a function of the system. And can it be fixed? I don't know. Is it broken? I also don't know. But I will tell you, when we talk about years and decades of appeals, this is what we're talking about. Decades of appeals. He is the Utah's longest serving death row inmate. Well, he is scheduled to meet the firing squad on September of this year. So in a couple of months now. Again, it sounds like he's exhausted all of his appeals, but that doesn't mean clemency can't be granted at the end. That doesn't mean some sort of emergency order regarding his health can't be granted at the end. That doesn't mean that there couldn't be some constitutional error found with the firing squad at the very end. These things are decades of this. And if this is spared from the Kohberger, from the victims, the Mogans and the Kernodles and the Chapins and the who did I miss? The Gonzalez family. If they are spared all of this as much as they wanted this, I think there's some silver lining there. There they are: Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin. Leslie Newman says, hey, mods, guess what? You all are awesome. We appreciate you, each of you dearly. Joshua, thank you for your time. Such a great community. The mods are awesome. Kaylin's awesome. Tiffany's awesome. Thank you guys all so much. Pilola's mom says, please scroll to see my question. Appreciate you, Josh and mods. Okay, we will try to find your, and here's your question. Look at that. The magic of YouTube. If the feds hired crash daddies, they knew there was no motor vehicle accident. So that the state of Massachusetts still proceed with charges against Karen. I don't understand. Thank you to the bestest channel. Here's what we don't know what the feds were investigating. And at the risk of having everybody throw spears at me here, I think what the feds were doing is they were trying to see, was there something so foul at play here that we can't allow this prosecution to proceed? This is obviously talking about Karen Reed. So they hired these experts, and the experts said they came to their conclusions. We all know that they were. They don't believe that this accident was caused by a motor vehicle accident. But that was their opinion. And that's what it is, an opinion. And don't come at me, but opinions, everybody's got one, okay? And the prosecution had experts, and they had opinions, and their opinions were very different from the defense experts' opinions. You may not like the prosecution experts. You may feel that the defense experts were better than the prosecution experts, but end of the day, everybody's talking about opinions here. There is the evidence, and then there's the opinions on what you can do with that evidence. The evidence was crime scene. Dead man laying in the snow, taillight fragments located around him, broken taillight on her car. This, the feds, I imagine, felt was enough to at least bring this to a trial for a jury to decide what took place here. But nothing we can imagine that the feds uncovered said to them that allowing this to proceed to a prosecution by the state of Massachusetts would be a miscarriage of justice. And that's the only thing that can be, I think, really gleaned from all of this. So when we say things like the experts proved there was no accident, they didn't prove that technically. What they proved was that their opinion, based upon their expertise and testing and everything else, and I think they did a fantastic job, but their opinion was X, Y, and Z. Anyhow, I hope that clears things up. I hope that I don't know if Pilola's mom is happy with me or angry at me or what, but there's the answer to your question. eBay Warhol, Tracy Fagan says, Sammy the Bull got transactional immunity. Maybe the feds are different. Sammy the Bull. Oh, yeah. Famous mafia case. Yeah, I think that, well, that's a great, thank you for bringing that up. That's a great example. And he got transactional immunity. And I wonder why the reason for that was. It might have just been that they felt like they could get no cooperation out of him unless they gave him that. Like a blank check. Like he didn't want to play games with any kind of use immunity, and the idea that they would try to, because he was so criminally involved that he probably felt like, you guys are going to try to screw me on this somewhere. I want transactional immunity. But great example, eBay Warhol for that. Oh, so now I understand. Thank you so much. Okay, Pilos, Mom. Good. I'm glad. All right. Appreciate the question from Haley from Cornwall. All right, let's keep it rolling here. Not me. Technical issues, not me.
Hey, Josh. This is Alex from Tulare County, California, right in your neighborhood. I have a question. Earlier this week, when you had Matt on, you guys spoke about the Menendez case. And can you actually explain or break down the habeas show cause order? Matt referred us to the 9th District, and I'm rusty on my legal vocabulary. So it'd be nice just to kind of have a little breakdown, because that was news to me. I had no idea. Love your show. Love everything you do. Love LA, obviously. I'm also a California girl. Real quick, too. Did you ever work with AJ Jackson, Just no big deal. I was just curious. But again, love your show. Keep doing what you're doing. Thanks.
Alex from Tulare County, California. Let's put you on the map. I actually had a case up there not too long ago. I had to drive all the way up to Tulare, so I know exactly where you're at. Great question. Let me answer your question about Alan first. Yeah, I know Alan really well, actually. I've known Alan. Oh my God. I've known Alan for 25 years or so. Is that right? Am I doing this math right? I've known him for a very long time. When I first was hired by the DA's office as a law clerk while I was still in law school, I was Alan Jackson's law clerk. I helped him prosecute Phil Spector for the murder of Lana Clarkson. And I've known him ever since then and been close friends, and he's been a mentor of mine. And then I was hired in the office as a DA, and we were both DAs together. He was obviously much higher up, involved in major crimes and everything else. And I was kind of the rookie that was working on other kind of lower level felonies. And then he left the office. And soon after that, I'd say within 3-4 years, I left the office to come work with him as a criminal defense attorney. And I was his law partner as a criminal defense attorney for about 5 years. So we've known each other for a very long time. He's an incredibly accomplished attorney. So yes, I saw Josh sitting behind AJ while watching a documentary on Phil Spector. Yeah. Yes. You saw Josh with much less gray hair sitting behind AJ. Would you rather go against AJ, the prosecutor, or AJ, the defense attorney? Boy, I do not know which side of my face I would want to have punched. That either one of those would be incredibly difficult. He's just a very bright, tenacious attorney, regardless of what side he's sitting on. I'll tell you this about him too. He could tomorrow be hired by a prosecutor's office and be just as zealous doing that. This is not some sort of idealism with him. He's an attorney. He's an advocate. Yeah, it was an amazing experience. You got him the good gray years. Yes. So, talking to Tiffany. Anyhow, to your question, Alex, about Menendez, let's go to, let's take a look at this habeas. So just to give you a quick background on what happened here. This whole thing started because they filed a habeas petition that was filed back in 2023, May of 2023. And what a habeas petition is it's your last appeal. So they are, like we discussed earlier, have exhausted all their appeals. Then the last thing you can file is a habeas. And the habeas has to be, hey, there's new information that should give us the opportunity to have this case revisited. And their new information was a letter from Eric to one of his cousins that was newly discovered. And then Roy Rossello, who was a member of the boy band Menudo, saying that he has also been abused at the hands of Jose Menendez. They put both of those into a motion. Then they say, we want to be heard and we would like a new trial. That petition was finally ruled upon last week, right? Or maybe longer. And I think it was last weekend or the whatever. We talked about it this last week with Matt Murphy. And basically what the judge said, if we can, do I have the habeas here to show you guys? Okay, here we go. What this basically said was there's what's called a prima facie case, which essentially means assuming everything to be true, you have met the standard of what is required to allow this to proceed forward. And the judge said, assuming everything to be true, assuming, there it is. It says order to show cause. I'm having a little bit of difficulty reading this, but I'll try to get it for you guys. It says, assuming the truth of petitioner's factual allegations, as the court must at this stage of the proceedings, the court finds petitioner, meaning the brothers, have made a prima facie showing that he is entitled to habeas corpus relief. Okay, so they have met that initial hurdle. Accordingly, respondent, or the DA's office, is ordered to show cause if he has why the relief requested should not be granted. And then he's got 30 days to do that. So in other words, all this is saying is the brothers are allowed to serve. And now it's up to the DA's office to volley back. How do they respond to this? The DA's office has already said, if you look at the top paragraph, respondent argues that both the letter, the Cano letter, and the Rosello declaration do not constitute new evidence under the definitions, and that the Rosello declaration is inadmissible and lacks credibility. And they also argued that the letter is procedurally barred as untimely. So we already kind of know what they're going to respond with, because they've done an informal response to this already. I still stand by the belief that this habeas will not be granted, but I am surprised that the habeas was allowed to proceed. But the judge is saying at this low standard of prima facie, assuming all the facts to be true, I find that it can proceed. So they have, of course, we might be having the habeas might be tail wagging the dog at this point. They have already been granted a resentencing. They are now eligible for parole as they sit in prison, and they have a parole hearing coming up August, I think, is their first parole hearing. They could be granted parole. Who knows? Before this habeas has ever even decided. So we'll see. This whole thing is playing out in ways that just absolutely has my head spinning. But yeah, the judge decided to go ahead and resentence them to 50 to life because they were youthful offenders. They're eligible for parole. Late August is when the parole hearing is going to take place. Many times people come up for parole and they're denied, but I feel like they got all of the wind in their favor on this case. So thank you, Alexandra, for the question from Tulare County. Appreciate you asking. All right, let's keep it rolling here.
Hi, Josh, and all the lovely CC crew. I'm Jackie from Leeds, West Yorkshire, UK. I have two questions, but they are connected. How much does the judge know about a case he is presiding over, or does he hear the evidence at the same time as the jury? My second question is, are the court bailiffs and the security staff given the heads up if the case is particularly heinous? I watched a trial and the poor law enforcement guy's eyes were on stalks listening to the evidence. Apologies for the broad Yorkshire accent, but that's the way it is. Love your channel, Josh. and try and watch it every time you're on. Thanks. Bye.
You are so sweet, Jackie from Leeds, England. Thank you so much for the kind words. Appreciate you calling in and asking a question. I love this question. I feel like this is something that people don't appreciate. And so I love when people ask these types of questions that kind of help all of us have a better understanding of how these things work. But how much does a judge know about a case? The answer is very little. In fact, before the case goes to prelim, the judge might know nothing about it. The judge is handed the charging documents, the criminal complaint, the indictment. And sometimes those things say something as simple as Bryan Kohberger is charged with the first-degree murder of these 4 individuals, and that's it. And he knows he's charged with murder. Now, the judge knows what's been on the media, and the judge is not blind, deaf, and dumb, and the judge can tell, what's been going on in the news. But what is the judge? Has the judge seen any evidence? Zero. And that is by design. The judge should not be seeing things that he does not need to see. The judge needs to be an impartial arbitrator of all of this. So we don't want the judge knowing all of this information. That can change by the time we get to the prelim, because the prelim is called a probable cause hearing. And so the judge needs to hear some of the evidence, but just enough to make a determination on whether or not there's probable cause to hold this person to answer for trial. The judge may also hear other information in the motions when they're talking about, like, for instance, Bryan Kohberger, when they were talking about the IGG and how that was collected. The judge is going to learn more as the case goes along, obviously. But many times the judges are watching the evidence play out in trial along with everyone else. And many times they're, hearing from witnesses for the first time, hearing about evidence for the first time. It's not all the discovery is not handed over to the judge. The discovery is not filed with the court. And that's why I'm saying that, in this case with the sealing order, when that sealing order is lifted, that doesn't mean that the discovery is all of a sudden handed over, because the judge and the court doesn't have it. And as far as the court staff goes, they know probably less. They know what they've heard in court, the bailiff or the court reporter. They know about as much as that's been said in court if they've been present, but it's not like anybody is given some sort of outline of what this case is going to be about. And yeah, I've seen that before too, where you will see reaction from court staff. I've been a part of cases where you can read the faces of the clerk or the court reporter and realize they're realizing these things in real time. It's funny, you make me think of this, but going back to the Phil Spector case, I remember the court reporter on that case, a really wonderful woman. Her name was Cindy. We became very friendly because you're with these people every single day. And she was so great because, she was such a great reporter, and she'd be listening and typing everything and going as fast as anybody could go. But she also would get these reactions on her face. She heard something in court. She kind of couldn't hide it, when she would hearing something play out in court, because she's hearing it for the first time. So great question, Jackie from Leeds, England. Appreciates you asking it. Say hello to everybody there in the UK. Laura, thank you so much for the gift. Appreciate that. Leslie Newman, thank you for becoming a member. Welcome aboard. All right, let's keep it rolling here. We got a great group of people watching. This is a good morning.
Hi, Josh. Hi, Mods. Hi, Tiff. This is Subi Sue from Reno, Nevada. And I just got finished listening to the judge's order on the lifting of the information for the Kohberger case. And I'm just livid. He said in his talk that actually Kohberger can still file for appeal, that there is a Supreme Court case. I'm just livid. I've been hearing from everyone that says no appeal, no appeal, no appeal. And now the judge is saying that he can appeal. So Let's talk about that one. All right. Thank you guys. Bye.
Subi Sue, Reno, Nevada. Let's put Reno. What is Reno's the greatest little city and the biggest little city? I forget. They got a great slogan. Reno, Nevada. This is a question that everybody was asking. Everybody was kind of losing their minds over this. It's funny. Gisela from Grizzly True Crime starts emailing me after this hearing takes place, and it's like, people are asking, you gotta answer them. You gotta give some people some answers, because everybody's kind of losing it over this thing. And I said, sounds like a great idea. And she said, how about you answer it on my show? So I went on Gisela's channel. Was that Friday? We'll put up the link for you guys. Oh, there she is. There she's giving me a smirk. Yeah. When was that? When did I come on there? That was on Friday, I think it was. I don't know. All the days merge into the same for me. But she invited me kindly to come on her show and explain it, and we had a great time. Really great discussion about the whole thing. We're going to put up the link. So go over there and watch it and tell Gisela hi and give her a shout out from Courtroom Confidential. But here is the Cliff Notes version of what we discussed, but you can watch a more fulsome discussion on Gisela's channel. But a couple things to understand. First of all, when you waive any right, whether that's your right to appeal or the right to counsel or the right to not incriminate yourself, whatever right, it has to be done so knowingly, voluntarily, and intelligently done. Okay. And those words encompass a lot. So in other words, if Bryan Kohberger could say my waiver of appeal should not be effective because it wasn't explained to me at the time what that really meant, or the judge didn't really ask me what that meant, or my attorney lied to me about what that meant, or my attorney threatened me to take the plea, or somebody else coerced me to take the plea, or I was bribed, or whatever it is. If anything can be shown that wasn't knowingly, voluntarily, and intelligently done, he has a right to withdraw his plea, or ask to withdraw his plea, or ask to withdraw his waiver. So if you want to call that an appeal or opening up the opportunity to appeal, that's one thing. The other thing is, and not to get too much into the weeds about this, but the judge referenced a case called Garza versus Idaho. And you have to understand that in the law, there's oftentimes extremely technical ways of thinking about things. And what the Supreme Court did in that case is they said, well, there's a difference between being able to effectively appeal and actually trying to appeal, I think is the best way of putting it. In other words, he could try to appeal. He could get out some paperwork in jail. He could fill it all out. He could put it in an envelope, put a stamp on it, send it to the appellate court. They would file it. They would open up, this request for an appeal. That is not going to be stopped. But the second he does that, the prosecution is going to file his waiver, the terms of his plea, with the court and say he's waived this. And that's going to be denied. So is there technically this idea that he has the ability to appeal in the most technical and lawyerly of ways? Yes, but he will never be able to appeal effectively because he's waived his right to it, unless that has to do with something where the waiver is ineffective for the reasons that we talked about before. I feel as I'm saying this, I may be making it more confusing and maybe not being all that helpful. But end of the day, the answer is this happens all the time. And it is a rock solid way of stopping people from appealing. He will not be appealing. All that we talked about before with the Menzies case and all of that, that's not going to happen. That is when people have a right to appeal. That is when they've gone to trial, been convicted, and they have the rights to appeal, and they just start filing. and it's going up and down the chain and every all other possibility. We will not be hearing from Bryan Kohberger in that way. But I don't know why the judge chose to say that in court. I don't know if he thought the firestorm he would set off, but that's not what we're talking about here. So thank you, Subi Sue, for answering that question. I'm glad that we got a moment to address that because I know a lot of people were concerned with it. All right. And again, hi to Gisela. Hope you're doing well. Thank you again for having me on. Appreciate seeing you and your support here and for commenting. But check out her video that we did together. It was a good time. All right, let's keep it moving.
Hello, friends. Madeline from Denver, as always, and you better be coming to CrimeCon if you aren't. This is not a Kohberger question, but it is a reference to it. So the hearing that happened on Thursday, everyone was virtual. It was Zoom. And then so we saw, like 7 faces on little tiny screens and the judge on another screen. What effect do you think that doing Zoom court has on the ability of the attorneys to argue whatever they're arguing? It seems like everyone was maybe more hesitant to talk or unmute themselves to talk. Do you think that if it had been in courtroom with everybody present, it would have maybe gone a different way? And in general, as Zoom court has become more of a thing, what effects do you feel it has? Yeah. Well, thank you, friends.
Madeline from Denver, Colorado. Thank you so much. Yes, Madeline, we will see you at CrimeCon. You better be there. We'll be there. This is you raise an interesting topic. So before COVID, the idea of any kind of remote appearance, Zoom appearance in court was unheard of. In fact, getting telephonic appearances in criminal courts was incredibly rare. I remember a couple of times I tried to make a telephonic appearance because I would be, on the south side of the county and I had another appearance on the north side of the county. And they were like, no, dude, that's not the way this works. This is a criminal court. We wear suits and ties here and we do really important stuff. And you better get in your car and drive the hour and a half or whatever it takes to get to the other side of the county to be here for your 5-minute appearance. Sorry. We're not going to do your 5-minute motion, continuance and picking another date over the phone. That's not how we do things. Then COVID happens and the world turns upside down and everybody realizes, oh, hey, we can do all this stuff remotely. We don't need to be sitting in court. I hate if I sound a little bitter here, but so much of a criminal defense attorney's time is spent driving, parking, walking to court, sitting in court while the judge calls every other case but yours for your 2-minute appearance to then walk back to your car, get back in your car and drive back to your office. The amount of wasted time that can be taken care of with these quick appearances that could be done telephonically or over Zoom is incredible. So part of it I love. Part of it I think is fantastic. And a lot of these court systems have not gone back and it's becoming much more common to appear telephonically, to appear through Zoom or WebEx or whatever else they're using. But I do feel there is also, it can be too much and it can be, it does have you cannot deny that it does affect the dynamics of what it's like to be inside of court. During COVID, I will tell you a couple of experiences I had. One, I actually argued before the Supreme Court of Indiana. Rare opportunity. It wasn't a criminal case. It was some other bizarre type of thing, but I did it from my office, sitting there on Zoom with the justices asking me questions and doing this presentation. I actually set up my computer so that I was standing because I just felt more comfortable to give this kind of a presentation. But very, nothing like that would be even considered if it wasn't for the lockdown at the time. And I actually did a trial during COVID all through Zoom, which was wild. And I didn't like it. I liked the idea that I didn't have to deal with all the nonsense I just explained, and there was some kind of convenience of having, the people helping you there, and you could kind of communicate with them easier. You just put yourself on mute and you can talk to somebody. But there's a definite dynamic of seeing the witness and cross-examining the witness, and that being live and in court and sharing the same space as all of this and all of the other kind of details and intricacies that cannot be picked up over the camera and microphone. I should explain it was a bench trial just in front of a judge, so it wasn't like a virtual jury, but wild times that we lived through. I agree with you. I think that for the most part, when these are important hearings, especially with witnesses testifying, it should be in person. But for a lot of this other stuff, let people call in, let people go about their lives. Yeah, doing it in my sweats, as Flora Paris says. Just, I feel like during COVID, I may not have put on suit pants for a good 6 months straight. Lee T says, I like how pets appear unexpectedly on camera in important Zooms. It does seem to be the timing. Usually I have little ones knocking on my door. All right. Great question, Madeline. Let's keep it rolling here. Okay.
Hi, Josh. This is Gina from Chapala, currently vacationing in Cabo. My question is, we are on the Pacific side, and we have been warned about strong undertows and riptides. This morning, I watched as a young woman with a little girl, I'd say about 7, and she was allowing her daughter to go into the waves. So the waves were up above her ankles, and she was splashing in the waves. I warned her that it was dangerous because I had seen several riptides already this morning, and she just gave me a thumbs up. Would she have any liability if her daughter was swept out to sea because she didn't heed the warnings? Is there any legal action that she could be taken against her for allowing her daughter to play in the ocean when she was told about the undertow and the riptides?
Gina from Chapala, Mexico. Let's put you on the map. Good to hear from you again. Good for you, Gina. First of all, good for you for saying something. And it's a great question. The answer to, in my view, Gina's question was, she's trying to warn these parents about the dangerous riptides. They got their kids playing around in the water, and they just kind of give her a thanks, lady. Thanks, but no thanks. Leave us alone. We know what we're doing. Kind of a thumbs up. Could they be in trouble if something horrible happens? And in my view, the answer is absolutely yes. And even more so because of the fact that you said something to them. So first of all, from a civil standpoint, I think negligence, absolutely there. But from a criminal standpoint, I think so as well. At the very least, I think you could argue child endangerment, that if you knowingly put your own child in harm's way under conditions that you were aware were dangerous, which would become an important thing as far as intent goes. And Gina, you warning them, put them on notice. It was a dangerous condition and they didn't do anything about it. And they ignored those warnings. I think child neglect or endangerment at the very least, but at the most, there's even an argument for, let's say something horrible happened and this child ended up losing her life. Involuntary manslaughter. I don't think that you could make an argument for any kind of intentional murder, but I think certainly criminal negligence, gross disregard for the danger and safety of others. An involuntary manslaughter, I could easily see a prosecutor's office, depending on the circumstances, what Gina said to them, how long that conversation lasted, if they were able to appreciate the dangerousness, if they should have been able to appreciate it given the surrounding circumstances and something horrible happened. I could see a prosecutor's office going for that. So great question, Gina. Good for you. I hope that child is okay. Please don't leave us hanging and give us the conclusion to the story. I hope everything worked out, but I'm glad you said something. All right, let us keep rolling here.
Hey Josh, this is Debbie in Kentucky. I live south of Scottsville, Kentucky. When I first started watching Courtroom Confidential, we were talking about the big cases that were coming up. And they were talking about juries and how they're going to get juries that don't know the cases and changes of venue and things. And I commented that I didn't know anything about these cases. I don't really watch the news. And you told me to be expecting my jury summons. And so I did. I kid you not. I got a jury summons within about 3 days. And I wondered who in Frankfurt was watching Courtroom Confidential. And I realized that's not really how it works. But I went this week for my date, and I was chosen for the district court panel. And they told us that we would be working with the Fourth, Fifth, and Sixth Amendments, and also something about sometimes the district court will send cases to the grand jury. So it's bound over to the grand jury is what they said. So I would love to know information, more things about what a district panel jury does and how that works. Thanks. Bye.
Debbie from Scottsville, Kentucky. See, don't mess with this show, man. Courtroom Confidential, getting people summons for jury duty since 2024. Love that story. I don't think I had anything to do with it, though I would love to make it sound like I did. But great question. District panel jury. I think what they're just saying there, Debbie, is that you're on standby. Usually when they talk about the panel, so you're in the panel for that district, it's like you're on standby. I know the way it works here in Los Angeles County is that you're kind of given a week of a window where you have to continue to call in to find out if you actually need to show up for a potential, a potential trial. Like it used to be that you had to show up and sit in a room day after day, wondering if you'll be called for a week. Now, I think they have you sit at home and call in, and then if they need jurors, they actually bring you in so that you only go into the courtroom where you might be selected for a trial. So I think that's what it means. You're on standby. There's a potential you could get called for trial. There's a potential that you don't. If they don't have many trials going on, I think the way that it usually works is you kind of have served your jury duty service if they don't need you. And it sounds like in your jurisdiction as well that they put you on the grand jury panel, that if they need grand jurors for whatever reason and you qualify for that, you might get called to that. So you're in for a treat, and you're welcome, because you brought it into existence by bringing it up here on Courtroom Confidential. But thank you so much, Debbie from Scottsville, Kentucky. Appreciate you sharing that story with us. All right, let's keep it rolling here. We're coming down to the final stretch here.
Hey Josh and crew, this is Amanda from College Station, Texas, home of Texas A&M University. I'm calling to get your take on the so-called attempted honor killing trial. That's Washington versus Ali and Ali, taking place this week. This is the case, I'm sure you're familiar with it, where there was a teenage girl, 17 at the time, she's 18 now, Fatima Ali, whose parents were trying to send her to Iraq for a arranged marriage to an older man. She didn't want to go. She is an Americanized teenager who spent her life here. She has a boyfriend here, and she attempted to avoid having to go by running away And her parents found her at a bus stop in front of the high school she used to attend. And mom allegedly held her dad down while dad strangled her. The boyfriend and many other bystanders intervened, detained him. She ran into the school screaming, "My dad's trying to kill me." They are now on trial, a jury trial. And I'm just curious on your take on this case, because there's so many elements in terms of culture and religion and what an American jury is going to see with these guys. So I'd love to hear your thoughts on how you would handle it, and just hear what you think. Have an amazing Sunday. Thanks so much.
Amanda from College Station, Texas, such a great question. And it was a question that a lot of other people had. So I want to spread the love. I want to make sure everybody feels included. I want to encourage everybody to call in. But it was funny. We had remarkably similar questions on this case from several of you. So here's what I'm going to do. First of all, shout out to Amanda in College Station. Then we're going to fly up to Coeur d'Alene, Idaho, and give a special shout out to Fauna in Coeur d'Alene, who had a very similar question. Then we're back in our jet down to Jackson, Mississippi, to Alyssa, who asked a question regarding this case. And then we take a quick bus ride over to Harrisburg, Mississippi, for Erica, who asked the same question. So this is a joint question for Amanda, Fauna, Alyssa, and Erica, all asking about the Ali, quote unquote, honor killing case. Oh, and Jill and Brian said they're watching the case. So here is the awful circumstances of this case. Ihsan and Zara Ali are a mother and father to a young girl named Fatima. She, according to what we know from reports, they had an arranged marriage for her that was to take place in Iraq. And it was to an older gentleman that she didn't even know. Well, Fatima said, nuts to that. I'm not doing it. She's either had been born in America or is very Americanized, living this world here, doesn't want to move back to Iraq where she might never return, to have this arranged marriage to a man that she doesn't know, who's older than her. Everything about it sounded awful to her. And one of the things that we've heard about is that the evidence of the arranged marriage is not going to be allowed in court. The judges ruled that the prosecution is not allowed to get into the idea that this was an arranged marriage. Now, she already testified, and she testified about not wanting to leave. But I don't know how close they got to that issue without touching it. And many people have gone, well, why in the world can't they get into that? And that's the whole point of this. And shouldn't the jurors understand that that's exactly? And I think it was Fauna made the excellent point of saying, well, listen, the jurors need to know that she's not just some rebellious child, that she actually felt like she was kind of fighting for her freedom in life. And that's why she did what she did. But here's why the judge did what the judge did and why I agree with the judge. First of all, I don't care what Fatima was doing. If she was fighting an arranged marriage or if she was throwing a fit over what they had for dinner. You don't kill your kids, right? So end of the day, Fatima's thoughts and what she was doing, there's no rationalization for it causing her parents to try to kill her. That's one way of looking at this. Two, motive is not an element. It's never an element to a crime. Prosecutors don't have to prove motive. They want to many times. It's helpful to the jurors many times. It's powerful evidence for the prosecution many times, but it's not a required element. So because of that, the judge isn't going to review excluding it as carefully as he might other type of evidence, okay? And a judge in a situation like this is doing what they always do, where they have to balance probative versus prejudicial evidence. So here you have Very probative evidence. It's very important, the motive behind this. We would all agree. Why she wasn't just a rebellious child, why they were actually trying to kill her because it has to do with whatever kind of cultural, religious, strong views that they had. But it's also incredibly prejudicial because it's inviting several things from the jurors. One, it could be confusing to them as to how they are supposed to use that evidence. Two, it may invoke issues regarding religion, culture, race, none of which should play a role in any of this. In other words, how is the jury supposed to use this evidence? Will they be able to use it properly, or will it bleed over into inappropriate things? And to avoid that happening and avoid that becoming an issue on appeal, I think the judge made the right decision. Many times judges are thinking about a case here, they're likely going to secure a conviction without this motive evidence, and this motive evidence is just too dirty. It's got too many problems. It's got too much baggage it's carrying with it, and to allow it is going to create problems down the road. So I think the judge made the right decision here. Mr. Ali is being judged by a woman, which makes my heart smile, says my cat's name is Karen. I like that too. Yeah, really, really horrific case. I think this case, though, more than anything, is going to come down to intent. I think that the defense has a real argument for this was about discipline gone wrong. I'm not saying I believe that's what was happening. I believe they were trying to kill her, but I think this was about, I think they could argue there's a cultural disconnect. We don't understand, these kind of public displays of physical discipline of a child, but we were trying to teach our child a lesson. We were not trying to take our child's life. And that's a big difference. If jurors believe that, then we're looking at some sort of assault case. If they don't believe that, we're looking at attempted murder, which could land them in prison for life. So really sad case, really fascinating case. We'll continue to watch it for you guys. Thank you so much to Amanda, Fauna, Elisa, and Erica for asking the question. All right, let's keep it rolling here, guys. A few more to go.
Hi, Josh. Hey, this is Kelly from Pleasant Hill, Oregon. That's kind of hard to find. It's outside of Eugene, Oregon. That's our closest town. I have a question about what do you think from like today's date prior has been the biggest trial in the United States? Well, I guess in the world, but specifically in the United States. What in all of our history has been the biggest trial that you think that we've ever gone through? Yeah, that's my question. I just wanted to get somebody in Oregon on the map. Every time I look, there's nobody in Oregon on the map. So I figured, I can do this. I can call in and let's get Oregon on the map. Thank you. Have a great day. And hello to all the other true crime buddies.
Kelly from Pleasant Hill, Oregon. I love it. Yeah, let's get Oregon on the map. I can't believe it. Is that true that we've never had Oregon before? Kaylin's giving me the yes. All right. Go Kelly, representing Oregon. And there you are in Pleasantville. This is a great question. And I'm already seeing people are giving answers. OJ, I see a lot of OJs. It seems to be across the board. People are talking a lot about OJ. I love this question because, first of all, I was thinking about how do you answer this? When we say biggest, I mean, there are certainly trials that took longer than OJ. There were trials that have taken, over a year, criminal trials. There are certainly trials that have involved more defendants. There are cases that have involved dozens and dozens of defendants. So it's a really interesting way to think about, well, what do you mean by biggest? And I think the way that Kelly meant and that we all think about it is what has had the most cultural impact is the way I was viewing this. When we think about that case was such a watershed moment case, we go back to cases like OJ. But we're viewing this in our kind of memory of things and how it impacted us. And I think there are other cases to think about too. I think you can go back to beginning with the case of Leopold and Loeb. This case, 1924, out of Chicago. These were two University of Chicago students. I know many of you know this, but I think if you don't, you should look it up. They kidnapped and murdered 14-year-old Bobby Franks for the fun of it. Two highly intelligent University of Chicago students who just wanted to see what was it like to murder someone. What was it like? Could they get away with it? It was a sick intellectual experiment. And they murdered this poor young boy, innocent kid, friends of theirs. He liked them. They knew him from the neighborhood. They had his trust. They were able to get him into the car because he trusted them. And they murdered this young man, this little boy. Horrible, horrible story. That captured the country, the entire country. I mean, this is before television and all of that, but the entire world was watching this, Leopold and Loeb. Then you flash forward to Los Angeles, 1969, Charles Manson murders absolutely captured the entire country. You're talking about 2 crime scenes, 7 people murdered. He goes first to the home of the Tate murders, kills people there, pregnant woman, slashing, leaving bloody writings on the wall, die pigs, helter skelter. A few nights later, the La Bianca murders, random people. Looks like Tate may have been targeted, but the La Biancas, just some random house in Silver Lake. And they killed this couple inside of there. Just blew everyone's mind. Something unheard of. This kind of inexplicable random acts of violence was just earth-shattering at the time. Huge case. Huge. And then, of course, what you guys are all pointing to, O.J. Simpson. That case, to me, I think it was the celebrity of it. I think it was now we had televisions inside the courtroom. It was the theater of it. It was the way it played out with Furman and Johnny Cochran and just, court TV every single day. I mean, it spawned an entire industry. Certainly, the lives of Nicole Brown Simpson and Ron Goldman tragically ripped from this world, and OJ walks. I mean, the whole thing. Any one of those. I think it's a great question. I love this question. I think it got a lot of us thinking about it. If you asked me to pick, I would say OJ, probably just because of the impact it had on my life. And I feel like just because of the modern exposure to media and television that we all have, it just kind of was blown up bigger than those other cases could have even possibly have been exposed. But great question. And then I'll tell you what, I think Bryan Kohberger would have been one of those. I think the Bryan Kohberger case, had it gone to trial, would have been one of these watershed cases. I mean, you're talking about senseless violence, the 4 beautiful lives lost, inexplicable motive, a defendant with no clear criminal background and understanding of what turns him into a monster. Ted Bundy. We haven't talked about Ted Bundy. There are plenty of them out there, but those are the ones that came to mind when I was thinking about this. So thank you so much, Kelly, from Pleasant Hill, Oregon, representing Oregon. Kelly, tell your friends in Oregon, why aren't they watching and calling into Courtroom Confidential? I don't understand it. Doesn't make sense to me. Thank you so much. Let's keep it rolling here. A few more questions, guys.
Hello, Josh. My name is Nishay, and I live in Philadelphia, Pennsylvania. My questions, and I have 2. One is about mental health. How do you maintain your mental health and make sure everything is okay despite the fact that you work with people during some of the hardest moments of their lives as by the time they're a criminal defendant, a lot of things have happened, and you got to take care of you, you know? So I want to know how you do that. My second question is about legal quirks. What are some legal quirks you've encountered in researching various cases around the US that are markedly different from the way you do things in your home state of California? Anything anything surprise you? Um, Thanks. And happy Sunday fun day, everyone. Bye.
Happy Sunday fun day, Nishay. Calling from Philadelphia, Pennsylvania. Thank you so much. Appreciate the question. Love these questions. Two great good ones. How do I maintain my mental health? It's rough. It's a constant battle. No, you know, I think, I mean, I obviously make efforts to get exercise and to eat right and try to sleep right. I don't do the sleeping part all that well. And then you've got the support of, Tiffany is my absolute rock and champion and helps me through everything. And then I've got these little critters here who, I don't know why that's not focusing. They help me keep me focused and centered. I think also going into this line of work in working in criminal law, both as a prosecutor and defense attorney, you also have to become really good about compartmentalizing. And yeah, ask Tiffany about that. I mean, she oftentimes by the time I get home, I don't really want to talk about my day. I don't want to talk about whatever horrible case I had to deal with. I want to leave it at the doorstep. I want to just enjoy my life and my beautiful girls and, talk about what's on TV tonight and what are we having for dinner. And that I know frustrates her a little bit. Sometimes she feels like she wants to know more about the cases I work on and the things I'm going through. And she'll always tease me because it's only until friends come over and we're all talking that she'll hear about some of the cases I'm working on, because I'll share some of those stories with them. But, I think that's part of maintaining your mental health, is just ability to kind of compartmentalize this. I'm taking off that hat and I'm putting on this hat. And that's how I'm going to get through all of this. Because if you think about it and talk about it all the time, you'll drive yourself nuts. Thank you, Nishay, for bringing that up. And to your other question about legal quirks, I think the way I at least took your question to mean is like, is there anything that's just weird or different about practicing in different parts of the country? And I've handled cases all over the country, different parts of the state that are a quirk, different. And one thing that came immediately to mind is there's a big difference. There's differences in every jurisdiction, little things that you have to learn. In Massachusetts, we saw they all have to stand. They all have to say, "May it please the court." They're very formal there. There's, I think they even refer to opposing counsel as brother. There's just weird little quirky things. One of the biggest differences I notice is in federal court, as I'm used to practicing in state court. That's where I've had most of my career, but I have had federal cases. And the first time I appeared for a federal arraignment, I'm in court. They bring everybody in shackles, and they're all sitting in this kind of area where you can go over and speak to your client. I'm introducing myself, saying I'm going to here represent you. This is your arraignment, blah, 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 blah. The case gets called, and you fill out a bunch of paperwork ahead of time, and the judge is going through the paperwork, and it's going as a typical arraignment usually goes. We're picking dates and everything else. And then I hear the judge goes, "Oh, counsel, I noticed that you didn't check the box to waive prelim. Was that a mistake?" And I go, "No, Your Honor. No, we're not waiving prelim." And the idea of waiving prelim on the state court level is unheard of. I'm never going to waive prelim. That's what your client's entitled to. Let's see what evidence the prosecution has. And when I say that, she goes, "Oh." And then she kind of looks around and she's looking at her clerk. And then I can see the prosecution looking over at me. And I realize, oh, I may have I may not know what I'm doing here. So I go, Your Honor, can I have a moment? And I kind of slink over to the prosecution and I pull him aside and I go, just shoot straight with me. Does everybody waive prelim? And she goes, yeah, that's just kind of how it's done in federal court. And I go, okay, gotcha. And I go back over to my client, tap him on the shoulder. I'm like, listen, I'm going to go ahead and waive prelim here just to just kind of grease the skids and get this whole case moving along. You're cool with that, right? Cool. Yes, Your Honor, that was an error. We would like to go ahead and waive prelim. And the judge goes, oh, okay, good. We move everything on. But it just shows you that you kind of, what I've always found to be the best way to adapt in these different jurisdictions and courts is you make friends with the clerk right away. And you also kind of have this aw shucks demeanor about you. And that's what I've always done when I've walked into a different courtroom, is immediately gone to the court and be like, hey, tell me how things are done here. I am just trying to make sure that everything goes smoothly. What do you want me to do? What do you need from me? I'm not trying to throw elbows. How can I help? And that just makes everything go more smoothly. And you shoot from the hip and you adapt. Sue Hugh says, I watch your show, Josh, but I just learned about you a month ago and I love everything about your show. And you've changed my mind about defense attorneys. Well, thank you, Sue. I appreciate that. We are not all vampires. I appreciate that. So thank you. All right. Always make friends with school, office, and nurse. Yeah. Kraken Studio. Very good point. Exactly my point. All right. Let's keep it. We got a couple more here, guys. We're coming down to the end. Oh, sad faces. Sad faces all around.
Happy Sunday Funday, Joshua, mods, crew, chat, everyone. Alicia K. Mayo, Humboldt, Tennessee here. Joshua. James Craig, Colorado. We all know what he's accused of. The defense's claim that he procured the substances in order for his wife to commit self-unaliving. Would that not be tantamount to admitting to assisted self-unaliving? I mean, I know he's a dentist, and Colorado has that, I forgot what it's called exactly, but the Compassionate End of Life Act. But I thought you had to go through the steps and you had to get the okay from the state of Colorado for that. So that admission or claim alone, well, wouldn't that serve the purpose as basically an admission that he is guilty? Thoughts, theories, whatever you want to talk about, Joshua. Thanks. Y'all have a great Sunday fun day. Bye.
Alicia K. Mayer from Humboldt, Tennessee, queuing me up to talk about whatever I want to talk about. I appreciate that. Always great hearing from you. This was great. This is what I love about this show. I never would have thought about this case this way had Alicia K. Mayo not brought it up this way. You're right. James Craig is the Colorado dentist. There he is, just looking about as pathetic as he can, who killed his wife, allegedly, fed her poison. When that didn't work, by the way, we have the opening statement to this case on our sister channel, Courtroom Confidential Live Trials. We're able to find that for you. Watch it. I didn't realize, I've been following this case very closely. I didn't realize they allege he actually went into the hospital while she was sick and fed her tablets that they believe were laced with cyanide to finish the job. Just, if true, pure evil. But his defense is she was having thoughts of self-harm and that she wanted to do this and that she asked him to procure the poisons so that she could willfully ingest them herself. Now, a lot of people have been going after the defense for this argument. And I agree with you. It is a garbage argument. But many times it's kind of one of those things, well, what else are you going to do? You can't stand up there with your hands in your pockets and say, nuh-uh, not true. I mean, sometimes you got to lodge an argument, and sometimes those arguments are ridiculous, but maybe some juror believes it. You don't know. But I agree with you. This kind of attack the victim thing is just really unseemly. But Alicia K. Mayo's point is, well, even if true, isn't that a crime? Isn't it a crime to procure poisons to help someone take their own life? Isn't that a problem? And I never thought about it that way. And I guess the answer to that is yes. I don't know what kind of assisted, self-harm laws they have in Colorado, but I can't imagine this falls into it. But I think their view is, hey, if he gets convicted of that, it's far better than getting convicted of first-degree murder. And maybe that's what they figure. If there's a juror out there willing to say, well, he's guilty of something, but it ain't murder, then go ahead and go for it. Alicia K. Mayo, justice for Angela and their children. 6 kids. This pathetic, go back to the pathetic picture of him. Pathetic man had a beautiful wife who birthed 6 beautiful children for him, and he was so selfish and wanted this life with another woman who had nothing to do with it, and maybe her life insurance or whatever it was, and decided to just ruin everyone's life by murdering his wife in one of the most horrible ways, poisoning her so she died over several days in pain. Yeah, justice for her and her family, for sure. All right, guys. This is it. This is the last one. Sad faces all around. Who's going to bring us home here? Not my fault. Technical difficulties, not my fault.
Hi, Josh. This is Kristen. I live in Whitensville, Massachusetts. It's about 45 minutes from downtown Boston. I have a couple of questions, but I'll just ask the one this time, and I'll call back another time for the second question. And my question, I actually put it in the comments a while ago, and I got a couple of responses, but I still don't understand the responses. And it started with a Sunday Fun Day a month or so back, where somebody posited the question about the movie Double Jeopardy with Ashley Judd and Tommy Lee Jones. And the question was in regards to could someone get away with murdering someone after they've been found, after they served time for murder for the same person when there was no body? So in the movie, Ashley Judd is found guilty of murdering her husband when in fact she didn't kill him. And then she later found out he was alive and was going to kill him because she served her time. And you had said you didn't think that Double Jeopardy would attach. You thought they would probably vacate the order and retry her if she in fact did kill her husband after serving time for killing her husband. And my question was, I had a question because you then later on had an episode with Lauren from Hidden True Crimes talking about the Barry Morphew case. And as a throwaway, you were saying how, it's a good thing that, okay, I'm going to hurry up because I got cut off. So you had mentioned that it was a good thing with the Barry Morphew case that the prosecution dropped the indictment, because had they continued on with the trial and had he been acquitted, and then later the body had been found with that BAM, that Double Jeopardy would have attached. And so I was confused because I'm like, well, what's the difference between that and the Double Jeopardy movie example where you had said that you thought that had Ashley Judd killed the husband after serving time for killing him the first time, they would have vacated the first verdict and retried her, whereas you thought with Barry Morphew, jeopardy would have been attached had he been acquitted. I guess I don't understand what the difference is, because you're still being tried, you're still having a verdict. So what is the difference? I hope that makes sense. Thank you.
It does make sense. Kristen from Whitensville, Massachusetts. Thank you. Thank you so much. Appreciate you asking this question. What I love about this, I imagine, if you guys haven't seen the the thriller from 1999 entitled Double Jeopardy, starring Ashley Judd and Tommy Lee Jones. Do yourself a favor and check it out. We watched it when this question was first asked a couple weeks ago. It's great. It's great fun. It's got plot holes you could drive a truck through, but it's great fun. It's a great movie. And it just caused everybody to have this kind of firestorm of questions about this movie. And is it realistic? And could it happen? And I love it because I imagine Ashley Judd poolside, opening up her mail, looking at her residual checks, and wondering why is Double Jeopardy all of a sudden getting all this new viewership recently? Why is a movie 30 something years old all of a sudden really starting to see an uptick in viewership? I love that. Anyhow, here is the answer, the very serious answer to your question. And it goes back to the Barry Morphew case. So maybe we should start with Morphew. Barry Morphew was arrested for the murder of his wife, Suzanne. Her body was still missing at that time. Right before trial began, the prosecutors dismissed it without prejudice. And everybody thought, oh my God, this guy's getting away with it. And he even, in fact, sued the prosecutor's office or the detectives, saying wrongful prosecution. Then her body is located, and then they do a toxicology, and then they find in her bone marrow, because her body had been completely it was nothing but bones. They find in her bone marrow this chemical BAM, which is a tranquilizer that Barry Morphew was like the only person in Colorado to have access to this. That's my very, very short version of what took place. So then they refile charges against him, and now he's going to face murder charges for the murder of his wife. And I had said that was a great thing, because think about this nightmare. Had he been tried and acquitted for her murder, Double Jeopardy would have attached, and if they ever found her body, he couldn't be tried again. And Kristen's saying, well, how's that any different than Ashley Judd? So here's the way this plays out. The government, it's not on the... When the government brings charges, it's on them to get their job done. So if their case isn't ready and it falls apart at trial, they don't get to revisit that just because they get evidence later on down the line. If they want to bring charges, they should be prepared to win those charges. Okay. And if they lose and later on they find a videotape with that person committing the crime, or they find the body with incredible evidence or whatever it is, Double Jeopardy has attached. That's how it works in the United States. Double Jeopardy has attached. Where things are different with Ashley Judd is in that movie, and I'm not doing spoiler alerts here, but watch the movie. I'm not going to ruin anything for you. She goes out on a boat with her husband, and she wakes up to a bloody scene, and she's got blood all over her, and he's gone. And she is arrested and tried and convicted for his murder. And then she finds out he's still alive. And people asked, because the premise of the movie is she can now go kill him and not be convicted again. And that is technically true, because she has been tried and convicted for the murder of her husband. She cannot also be subsequently tried and convicted for the murder of her husband. What I was saying, though, when we talked about that, is what would likely happen, and you ask a lawyer a question, you're going to get a nerdy answer. What I think would likely happen is that the prosecution would file to have her original conviction vacated, because they would say, in the interests of justice, we now have evidence that this woman did not commit the crime she was originally convicted of. She was originally convicted for the murder of her husband on this date on this boat. We now believe that that murder did not take place. We would like to have that conviction vacated. And then we would like to try and convict her for the murder of her husband that takes place on this later date at this other place. That's how I thought it would work out, because what they would actually do, Double Jeopardy would apply. They would have to deal with Double Jeopardy. And the way that they would deal with it, Kristen, is that they would likely vacate and exonerate her so the double jeopardy didn't attach, and they could then try her for the subsequent murder of her husband. Can't spoil a 30-year-old movie. I think you can, Northwest. I think you can. It may be 30 years old, but you might find it is in high demand recently in viewership. Anyhow, yeah, I think they would have to deal with double jeopardy is the answer, because there would be an argument she's already been convicted of the crime of murdering her husband. But I think there would be also an argument that, well, we vacated it, or two, it's not the same crime because I don't know. It's an issue. It's a wonderful issue. I think they would have to vacate it. They'd have to vacate it and retry her. Anyhow, Yvonne says your channel is growing rapidly. Sunday Funday will turn into 5-hour live stream. I'm here for it. I love the knowledge you share with us and your time. You're very sweet. I don't know about 5 hours. Tiffany would probably murder me. And then we'd have to figure out if she could be retried or if double jeopardy would attach. Barbara North says, Josh, you're so generous with your time. Thank you so much for raising our legal consciousness. What a sweet and kind way of putting it. Kay Schmidt gives some memberships. I appreciate that, Kay Schmidt, for your generosity. That's it, everybody. Let's do some announcements and get you out of here. What a great question to go out on. First of all, like I said, just before the show, we hit 48,000 subscribers. Thank you guys so much for all of that. If you don't already, please follow us on Facebook at Courtroom Confidential, on Twitter at CR Confidential, and on Instagram at The Courtroom Confidential. Really trying to kind of beef up our following there so that we can offer you guys more perks. As always, please check us out at thecourtroomconfidential.com to find all of these things and how you can become a member and how you can leave a voice message and how you can find some of our merch, including, what am I wearing? What is this? What color is this? Most important question of the day. What color is this? Plum, lilac, lavender, says CH. Tiffany, it's the most important question. Diane L says violet. Court Lurker. Oh, violet. It's violet, everybody. If you want a violet t-shirt, go to thecourtroomconfidential.com. Let me just flash our website for you guys really quickly so you can see what I'm talking about. Go to thecourtroomconfidential.com for our how to become a member. You click on become a member. You go to the shop for all of the shirts and everything like that we just been talking about. We're going to be adding some new stuff soon, by the way. Like I said, click on become a member and you can find out all the perks of membership. And a lot of you have done that. And if you click on send us a voice message, you get this little box where you can leave us a message for next time. So please check that out. We've been putting a lot of work into the website. CrimeCon coming up. I talked about it already before, but we have a discount code for you. If you're going to join us in September in Colorado, just enter the discount code Courtroom and you get 10% off your purchase for tickets. What did you miss on Saturday? We had our weekly roundup. Big show for us. It was a very popular show. We talked about Rex Heuermann and Bryan Kohberger and Karen Reed and James Craig. So check that out. It's already up. Then stay tuned this week. All this week, I'll be in Boise. I'm leaving tomorrow. Leaving the girls, leaving Tiffany to take care of all of our little maniacs at home, going up to Boise, and I'll be there through Thursday. And stay tuned to be determined programming because Kevin Fixler's up there. Joel Waldman from Surviving the Survivor is going to be up there. We're all going to be hanging out, and we might just hop on here or there and send you guys some interesting spur of the moment programming. And then Monday, because I'm going to be flying, we can't do our normal Monday night live. So instead, we sat down with Anna Garcia of True Crime News this is one that you guys have been asking for. Anna has had an incredible career, still has an incredible career, but we sat down and did an interview with her for our conversation series. We will be premiering that tomorrow at 5 p.m. Pacific, 8 p.m. Eastern. Please show up, show your support, send her some love. I think you guys will really enjoy the conversation. And then we will be doing a Wednesday night live. That is the day of the sentencing. I just don't know. I don't know the plan. It's TBD. It will be, if I can move heaven and earth, at 5 p.m. Pacific, 8 p.m. Eastern, when they normally are at. But I just don't know where it's going to be. If I'm going to be in a hotel room, or if I'm going to be standing in front of the courtroom, or if I'm going to have a guest or not have a guest. We're going to try to work that all out in idaho. But whatever it'll be a great time. Grizzly True Crime says she loves Anna. Grizzly's been on True Crime News, so check out that episode. All right, guys, you're the best. Thank you so much. This is fantastic. All of this is possible because of you. We are humbled. We are blessed. We are so grateful for all of your support. Thank you for spending some time with us on a Sunday, and have a great weekend, everybody. Take care.